So the Supreme Court has granted, vacated, and remanded a Second Amendment decision which runs contrary to their recent decision in New York State Rifle and Pistol Association v. Bruin. So let's talk about this. But real quick before we jump into this video, if you think we need more Second Amendment rulings of the Supreme Court, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. Also, they are having an expo, and that's going to be from November 11th through the 13th. I will be at the expo, so if you're interested, I will leave a link to that down below. It'll have all the information you need. And so if you're interested, come to the expo, hang out with me and other creators who are also going to be there, and it should be a really good time. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and at a national level while serving as a staff attorney with the Firearms Policy Coalition legal team. As I mentioned in the intro, in this video, we're going to be discussing how the Supreme Court recently granted, vacated, and remanded another Second Amendment case using their recent decision in New York State Rifle and Pistol Association v. Bruin. The case we're talking about in this video is called Morin v. Liver. In this case, the Supreme Court overturned a First Circuit determination that an individual who had a nonviolent misdemeanor could be denied the ability to acquire a permit to purchase a firearm and also be denied the ability to carry a firearm concealed and could be denied a carry permit. Petitioner Dr. Alfred Morin is a Massachusetts resident who in October 2004 traveled to Washington, D.C. with a handgun. At the time, Dr. Morin had a Massachusetts license to carry. That was his carry permit, but he didn't know that D.C. did not recognize his permit and that he was prohibited from carrying his firearm concealed within the D.C. limits. While attending the American Museum of Modern History, he saw a sign that prohibited firearms, so he decided to approach a guard to inquire about checking his concealed handgun. The police officer then, upon finding out that he had a handgun concealed, arrested Dr. Morin, and then he was charged with carrying a pistol without a license and possession of an unregistered firearm and the unlawful possession of ammunition, and that was all under DC's codes. On November 8th, 2004, Dr. Morin pleaded guilty to attempting to carry a pistol without a license in violation of those DC codes. The Superior Court of DC sentenced Dr. Morin to 60 days imprisonment on each of those counts, and they also gave him 20 hours of community service because of those violations. In February of 2008, Dr. Morin submitted an application to renew his LTC in Massachusetts, but after learning that he had that 2004 misdemeanor conviction in DC because he was carrying that handgun concealed, the chief of police in Massachusetts then decided to deny Dr. Morin's renewal application. In February 2015, more than 10 years after his guilty pleas, Dr. Morin applied again to get his LTC license, and he was denied once again. He was denied that application because of that prior nonviolent misdemeanor. He then sued for a deprivation of his rights to keep and bear arms. A district court in reviewing his case found that the right to carry outside the home is different from the core right to possess a weapon inside your home for self-defense. Since it did not impact a core right, the court found that as long as the restriction served an important purpose, an important governmental interest, an important public interest, it was therefore valid. He then appealed that decision. The First Circuit ruled that there was no constitutional deprivation because of a firearms identification card could be obtained by him, and in conjunction with a permit to purchase, that would allow him to acquire a firearm and therefore possess it in his home and be able to defend himself, which they believed was one of the core rights of the Second Amendment, but that it exclusively limited him to only be able to have a firearm inside of his home for self-defense. Again, the court is limiting the core right to only exist within the home, saying that with an FID card and a permit to purchase, he would be able to exercise his right to keep and bear arms. Well, after the First Circuit's ruling, Dr. Morin submitted an application to get his FID card and also a permit to purchase. However, both were denied because of that prior misdemeanor arising out of that incident in DC. Dr. Morin then filed another lawsuit claiming that without a license to carry or a permit to purchase, he essentially had no lawful method to acquire a handgun and then even use it within his own home for self-defense. The district court in reviewing this issue granted a summary judgment in favor of the Commonwealth of Massachusetts. The court used intermediate scrutiny to reach its decision, which is a lower bar of analysis which the Supreme Court just struck down. The district court on review found that individuals convicted of weapons-related offenses punishable by a term of imprisonment are not the type of law-abiding, responsible citizens contemplated by the court in Heller. The First Circuit also stated that Dr. Morin was not outright banned from obtaining a handgun since he could inherit one and therefore have it within his home for self-defense, even though the court acknowledged that Dr. Morin at the time did not have anyone in his family who he could actually inherit a firearm from. So that is the long and complicated mess and background which led to this case making its way up to the Supreme Court and for him seeking Supreme Court review. This case was interesting and was perfect for Supreme Court review and perfect for a GVR, especially since the First Circuit had used various types of incorrect standards in reaching their prior decision, including the use of intermediate scrutiny. In Bruen, the Supreme Court made it clear that the correct type of analysis when looking at the Second Amendment is text as informed by relevant history and tradition. The Supreme Court also stated that in Bruen, the use of intermediate scrutiny should never be used in Second Amendment cases. Therefore, the First Circuit's analysis in this case should be completely invalid. Also in this case, one of the interesting things is that the First Circuit said that the Second Amendment does not exist outside of your home, that it only applies to self-defense within your own home. However, we know that that is not correct, and Justice Thomas in Bruen once again stated that nothing in the Second Amendment's text draws a home/public distinction with respect to the right to keep and bear arms, and the very definition of bear naturally encompasses public carry. However, in response to this petition filed by Dr. Morin, the state of Massachusetts tried to argue that the Bruen decision does not impact this case at all. They only dedicate about 2 paragraphs in their response, and essentially it's a simple argument. They say that since they claim Dr. Morin is not a law-abiding responsible citizen, Bruen and that decision does not apply because they say Bruen only mentions the protection of the right to keep and bear arms for law-abiding responsible citizens. They state that nothing in Bruen suggests that individuals with criminal convictions can qualify as law-abiding, nor did anything in Bruen suggest that individuals like the petitioner with weapons-related criminal convictions can qualify as responsible, as those terms were historically understood. But the Supreme Court did not buy those arguments. In fact, the Supreme Court did grant, vacate, and remand this case back down to the First Circuit for them to reconsider their decision in light of Bruen. That means no more intermediate scrutiny, no more interest balancing, and no more arguments that the Second Amendment does not apply outside of the home. Also, this GVR is really important because it shuts down this argument that Bruen and the decision does not apply to prohibited persons and prohibited person cases, essentially those people who maybe have nonviolent misdemeanors or felonies like Dr. Morin has. The state of Massachusetts tried to argue that Bruen only applies to cases where it involves a so-called law-abiding individual, but the Supreme Court just rejected that argument and still GVR'd this case, GVR'd a nonviolent misdemeanor case, sent it back down to the First Circuit for them to reconsider it, actually using Bruen. So the GVR of this case under Bruen, in my eyes, really opens a huge door to now start challenging various lifetime purchase bans, carry bans for those people who maybe have nonviolent misdemeanors that makes them a prohibited person in various states and areas, and also maybe even those people who have nonviolent convictions of felony convictions, maybe opens the door to challenge those types of restrictions as well. So that's a quick rundown of what happened in this case in a recent GVR from the Supreme Court under their recent Bruen decision. So it will be really interesting to see what happens from here, how the First Circuit is going to handle this, because all of their prior arguments using intermediate scrutiny, that the scope of the Second Amendment doesn't apply outside of your home, all of those arguments are now 100% invalid. And even more so, like I mentioned, even the argument that Bruen doesn't apply to prohibited persons or people with nonviolent misdemeanors or nonviolent felonies, now that argument that Bruen doesn't apply to those cases is 100% invalid because the Supreme Court just GVR'd one of those cases and has told them to reanalyze the case using Bruen. So if you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of 2A news. I also want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.